Well, hello everyone, and welcome to Uncivil Law. As always, I am Uncivil Law, and I hope you're having a great evening where we are learning through the misfortunes of others. And today we're learning through the misfortunes of Mr. Legal Eagle himself, Devin Stone, who would like to get some information out of the Trump White House and other entities. So, Mr. Legal Eagle sued the federal government under the Freedom of Information Act for information related to the screening and censorship of John Bolton's book in the room, the room where it happened. So John Bolton, who is a national security advisor for Trump for some period of time, wrote a book about the Trump administration, and it was reviewed, and I forget exactly what happened. Was it censored in part? Was it blocked in part? Was it published without permission? I can't remember the exact details, but whatever. Today we're talking about the internal processes that the federal government used to review the book and what they did in certain stuff. So he'd like to get access to the internal review processes of how this book was written or how this book was reviewed. Because being the former national security advisor, of course, he has a security clearance. And if you have a security clearance when you are writing books, you usually have to run them by the agency that you worked for to make sure it doesn't contain any secret material. So his book was reviewed like they all were reviewed, and then he wasn't allowed to publish the things he wanted to publish. And it's because of Orange Man, not because of, National Security Act. Oh, well. Anyway, so we're going to read this decision from the judge today. Granting in part, dismissing in part, a whole bunch of stuff, and we're going to figure out what's going on. So let's go with this. All right, great. So we have a memorandum opinion granting the defendant, that would be our friends the government, defendant's partial motion to dismiss, denying plaintiff's motion for partial summary judgment, granting defendant's move for partial summary judgment, denying plaintiff's motion to strike. Okay, so the plaintiff, which is Eagle wanted partial summary judgment. He didn't get it. The defendant, the government, got part of this dismissed, and they have one part of it on summary judgment. And I guess some of it is still alive for the moment, for further analysis a different day, but, whatever. So let us read this and good stuff with that. In this case, brought pursuant to the Freedom of Information Act, the plaintiff, Legal Eagle, a business that runs a YouTube channel focused on legal issues, seeks records related to the pre-publication review of former National Security Advisor John Bolton's book. John's Bolton book, The Room Where It Happened. Legal Eagle has filed an amended complaint with 21 causes of action, all brought under the Freedom of Information Act, related to various requests for records and requests for expedited proceedings. Legal Eagle named as defendants the National Security Council's Records Access and Information Security Management Directorate, RAMSD, the Central Intelligence Agency, the Department of Defense, the Department of Justice, Department of State, National Archives and Record Administration, and Office of the Directorate of the National Intelligence. Basically, pretty much all the people who have interest in national security for the federal government. RAMSD has moved to dismiss all the counts against it, arguing that under binding D.C. Circuit precedent, the National Security Council and any of its subcomponents are not subject to Freedom of Information Act. So that would be one thing, right? So the National Security Council is a group within the White House, and maybe it's not subject to the Freedom of Information Act at all. So its directorate might also not be subject to the Freedom of Information Act. That could make sense. The Freedom of Information Act is, after all, just a law like any other law, and it might not apply in this situation. So, okay. Additionally, Legal Eagle filed a motion to strike defendant's cross motion for partial summary judgment, arguing that defendants failed to adhere to proper motions practice procedure. So he wanted to say that the government failed to follow motions practice procedure. It seems a bit unlikely, but okay. For the reasons discussed, the court will grant RAMSD's motion to dismiss pursuant to Armstrong versus Executive Office of the President as a subcomponent of the National Security Council, which is not subject to the Freedom of Information Act. The court finds that RAMSD is not subject to the Freedom of Information Act. With respect to the motions for partial summary judgment, the court agrees with defendant that based on records before the agencies, the records for expedited processing were properly denied. Properly, the court finds nothing procedurally improper with defendant's cross motion for partial summary judgment and therefore will deny the motion to strike. All right, so that's a whole bunch of stuff. So the National Security Council is an entity within the White House as opposed to an agency of the government, right? So that's probably where this is going to break down, if I had to guess, without even reading the law, right? So without even reading the law, why would this outcome come into play? It's because it's within the White House, not an agency of the executive. It is the executive. It's too closely associated with the executive. So the National Security Council, first of all, who's on the National Security Council, is kind of up to the president in the first place. And so the directorates within the National Security Council are also kind of up to the president in the first place. So I'm going to guess that this is all just kind of part and parcel of the president, who is also not subject to FOIA in and of himself. So yeah, that makes pretty good. So let's see what we got. Background. As alleged in the complaint, Legal Eagle runs a YouTube channel focused on legal issues with more than 1 million subscribers, 10 million monthly views, and 100 million total video views. He's very proud of himself. The channel features a recurring segment entitled Real Law Review, in which the host, Mr. Devin Stone, explains the legal issues behind major stories in the news for a general audience. The company seeks records related to the pre-publication review of the manuscript written by former National Security Advisor John Bolton. So as I mentioned in the introduction, when you have security clearances, you often have an obligation to run anything you want to publish by the agency or agencies you worked for to make sure it doesn't contain any classified materials. So you can't obviously write about things that are classified. Even if you experience them, they're still kind of classified. That's what classification does. Any person who possesses a security clearance must sign a non-disclosure agreement. That includes an agreement to submit any manuscript related to national security employment for pre-publication prior to disclosing to a third party. This is pretty typical. Yeah, most security clearances require a non-disclosure, and most of the non-disclosures say you have to run anything by us in advance. The review process that's generally handled by the agency that sponsored the clearance allows the government to deny an author to permission both classified and unclassified information depending on the circumstances. If it's particularly sensitive, it's possible, right? So that would also be like work products. So if you're thinking about like why they might not allow you to print unclassified things, right? Just because it's unclassified doesn't mean that it's in the open. So you can have things that are held closed but are not classified within the traditional classification structure. So, and also anything that you have unclassified, strictly speaking, unclassified, could nevertheless relate to classified things, right? So, I'm suppose that you had some op that you were doing in Italy, and you're writing, well, I flew to Europe. Well, that isn't necessarily disclosing it, but maybe it's too closely connected or something like that. So, yeah, they can get to some of the unclassified details, particularly if they have relations to the classified aspects there as well. In 2019, the RAMCID conducted a pre-publication review of Mr. Bolton's book, The Room Where It Happened, and determined that it contained classified information. In June of 2020, despite ongoing pre-publication review and determination that it contained classified information, Mr. Bolton had it printed and shipped to distributors across the country. This led the government to seeking a temporary restraining order. Although the judge denied the motion, he stated the court is persuaded that defendant Bolton likely jeopardized national security by disclosing classified information in violation of non-disclosure. So, yeah, Mr. Bolton here is potentially liable for violations of the National Security Act as a result of all that. So, that's possible. I don't remember if Trump pardoned him or not. Trump pardoned Bolton? I can't remember off the top of my head. But if he did, he would be responsible for that, so yeah. Legal Eagle submitted a series of FOIA requests to defendants seeking records and information regarding Bolton's book, the pre-publication review process, and information the government prohibited or attempted to prohibit from publishing, which they're not going to tell you because they can't tell you the information they prohibited, because if they did, they'd be telling you classified information, so no. Alongside the records, Legal Eagle submitted requests for expedited processing. The request for expedited processing explained that Legal Eagle runs a YouTube channel that is focused on information from the public about legal issues, and the requested information concerned operations or activity of the government. In addition, the requests for expedited processing include the following statement. Because this is coming from Legal Eagle at this point, by the way, in case you lost the thread. So Legal Eagle said, because of the issues surrounding Mr. Bolton's manuscript and government's efforts to prohibit him from publishing the requested information, either in his book or congressional testimony, which, if it's classified, that has to be given in a classified session, right? You can't give classified mirror information in an open session. They have classified sessions of Congress, too. This request satisfies the compelling need standard for expedited processing since it's made by a person primarily engaged in disseminating information to inform the public about governmental activity involving topics of breaking news. Two officers, the DOJ and the Office of Legal Counsel, agreed to expedite his request. So he submitted these requests to many different agencies, as we discussed above, right? And so all the agencies are considering his requests independently. So the DOJ and the Office of Legal Counsel said, sure. 5 offices denied Legal Eagle request to expedite, and Ramsden did not decide the matter with respect to 3 requests because they didn't think FOIA applied at all. Counts 2, 4, 6, 8, 12, 14, 16, 18, only even number requests, I guess, of the amended complaint charged defendants with improperly delaying or constructively denying, in the Ramsden case, Legal Eagles to expedite. This is going to be agency discretion. I mean, it just reads agency discretion all day long. The court is not going to overrule this unless it's blatant. It's just not going to happen. I mean, you can ask for lots of things, but no. Pending before the court is several motions. Defendant filed a partial motion to dismiss, arguing that Ramsden is not subject to FOIA because the National Security Council, which is part, is not subject to FOIA under the relevant law. Legal Eagle filed a motion on the counts to its respect to expedite processing. We can't expedite something that we're not required to obey in the first place. I suppose we can expedite our no, but no. In response, defendant filed a cross motion for partial summary judgment. Finally, because Legal Eagle argues the defendant's cross motion was improperly filed, it filed a motion to strike the motion and reply in support of that motion. The pending motions are all brief and ripe. Okay, great. Let's read some on. The federal rules of civil procedure require that a complaint contain a short and plain statement of the claim in order to give defendant fair notice of the claim. Right, we call it notice pleading. You don't normally have to go into details. There are a few exceptions, but generally you just have to give people fair notice. A bare bones complaint is normally sufficient. A motion to dismiss for failure to state a claim does not test a plaintiff's ultimate likelihood of success. Rather, it states whether there is a claim. So we're not trying to analyze how likely you are to win in failure to state a claim. Just, is there one? Is there one that's legally cognizable? The complaint's factual allegations are to be taken as true, and the court is to construe them in plaintiff's favor. Even Legal gets the benefit of this rule, right? Everything the plaintiff says is true, so everything Devin says is true. And if you don't think that hurts me to say out loud, you don't know me very well. Notwithstanding this liberal construal, the court deciding the motion must parse the complaint for sufficient factual matter accepted as true to state a claim. It's minimal, but it still exists. If you don't have enough, then you don't have enough. Right? So you do have to look for sufficient that it would be, if true, you could win. So it's minimal, but it's something. The plausibility requirement means a plaintiff's allegations must be enough to raise a right to relief above pure speculation. Again, the standard's pretty low, but it has to be like more than a theoretical chance. It has to be low, but not speculative low, on the assumptions that all of them are true. Thoroughbred recitals of elements of cause of action supported by mere conclusory statements are insufficient. So yeah, just reciting the elements is not enough. Mere conclusion is not enough. You actually have to supply some facts. Any facts would be fine that would help to support the elements of the claim. A court need not accept legal conclusions as true because that's not for them to decide. They don't decide law. That's what courts do. nor must the court presume the veracity of legal conclusions. Again, that's what courts do with their time. A dispute is genuine if there's enough evidence for a reasonable jury to return a verdict for the person who is not moving for it. The primary purpose of summary judgment is to streamline litigation by disposing of factually unsupported claims or defenses and determining whether there's a genuine need for trial. The movement bears the initial burden of identifying portions of the record that display the absence of any genuine issue of material fact. In response, the non-movement must point to specific facts in the record that reveal a genuine issue that's suitable for trial. In considering a motion for summary judgment, a court must eschew making credibility determinations or weighing evidence. Yeah, they're not trying to determine credibility for the things that matter in the motion for summary judgment, unless I suppose it's completely non-credible, or weighing the evidence unless again it's so overwhelming, right? So we're not trying to weigh things. So unless it's, absurd, you don't normally look to things once it's properly within the motion to dismiss. All underlying facts and inferences must be analyzed in the light most favorable to the person not asking for it, which we've discussed this many times. Plaintiff's partial motion to dismiss relies on D.C.'s circuit decision in Armstrong, which concluded that the National Security Council is not an agency within the meaning of FOIA. That's what this breaks down to, whether or not the National Security Council is an agency. And it's really not. It doesn't really have a permanent structure, and it doesn't really have a bureaucracy. It kind of exists at the pleasure of the president. And it's kind of whoever the president wants to be on it, really. So, yeah. It's a mechanism to provide information to the president. It's kind of an entity within the White House. So it exists or not. It's not an agency. Because RAMCID is an office within that, which also is kind of made up, defendants contend that, like the National Security Center as a whole, it's not subject to FOIA, which makes sense. Something that's a subordinate component of something that is not an agency also is not an agency. Legal Ego argues that it's plausibly alleged that RAMCID's function is sufficiently distinct from the National Security Council as a whole to render it as inapplicable. So Legal Eagle here thinks that although they're a sub-entity, somehow they are independent at the same time, or distinct enough at the same time. So they're both a subcomponent and distinct. Yeah, that doesn't really work. FOIA's record disclosure requirements apply to agencies, a term which includes any executive department, military department, government corporation. I feel like I have to stop here just to explain this to the sovereign cits. Okay, the government as a whole is not a corporation, but there are entities within the government that are technically classified as government corporations. I believe the Postal Service is, unless memory fails me completely. But yeah, there can be government corporations. The government can own corporations, or instead of it being structured as an agency, it can be structured as a corporation. So there aren't very many of these, but they do technically exist. That doesn't mean the government as a whole is a corporation. Government-controlled corporation or other establishment in the executive branch of the government, including the executive office of the president or any independent regulatory agency, although the definition explicitly includes the executive office of the president. The D.C. Circuit has recognized the definition was not meant to cover the president's immediate personal staff or units within the executive office whose sole function is to advise and assist the president. So, FOIA does not apply to the president. It does apply to the executive office of the president. So, the courts, in trying to figure out where these boundary lines are, have said, okay, if it's an entity that is directly serving the president to provide advice and assistance, if that's their only purpose in life is to advise and assist the president and nothing else, then they are kind of within the confines of the presidency rather than an agency. The D.C. Circuit has developed a 3-factor test to determine what status the FOIA units of the executive office of the president. The factors to be weighed are how close operationally the group is to president, whether it has a self-contained structure, and the nature of its authority. In the relevant case, the D.C. Circuit has analyzed these factors to determine whether the National Security Council is an agency. The court concluded that the National Security Council has a structure sufficiently self-contained that the entity could exercise substantial independent authority. Second, the court found the National Security Council's intimate organizational and operational relationship with the president is entitled to significantly greater weight in evaluating the arguable status as an agency than the self-contained structure of that agency. So, in the second factor, the court looks to the relationship between the entity and the president as more important than how the entity itself is constructed. The court notes that the president chairs the Security Council, and the National Security Advisor, working in close contact and under direct supervision of the president, controls the staff. The court then turned to statutory and presidential delegations of authority, which is the third factor. Most importantly for the case, the court has considered the National Security Council's delegated authority to protect national security information. The National Security Council has argued that merely monitors other organizations in order to assure the objectives of the president, who retains ultimate authority over classified information. That's true. The National Security Council doesn't really generate information from itself. The National Security Council reviews information from other entities. Usually the CIA director, for example, is on it, or usually the NSA director, or usually the director of national intelligence, or usually the head of the FBI. These are entities that can be in it. So the agencies that create the information report to the NSC. The NSC doesn't really create the information in the first instance. The National Security Council explained that declassification reviews are really nothing more than internal management of information that the National Security Council generates and advises the president. Despite Armstrong's argument that the National Security Council had an independent and discretionary role in declassification review for entities outside of the National Security Council, the court did not consider this evidence indicative of entity with substantial independence from the president, which is true even for a lot of agencies. Like even the FBI, even the DOJ, even enter your agency of choice, even where their head is appointed by the president and it's fully within the executive, they still kind of are independent a little bit, right? They don't really, if you take a random agency within the federal government, the bureaucracy runs, constantly. That's not really true for the National Security Council. It kind of doesn't really operate that way. It doesn't really have a permanent established existence in the same way. The defendants argue that Armstrong resolves the case. They argue that a federal entity must be treated like its parent entity, and Ramsden is not even appropriately named as defendant, as under FOIA, the parent agency constitutes the proper defendant. So if you were trying to sue some sub-elements within, the census, if you're trying to get some information from the census, you wouldn't apply for that information within a subcomponent of census. You'd ask for it from census. Defendants argue that entity, the National Security Council, itself lacks substantial independent authority and exists only to advise and assist the president, cannot have a subordinate subpart that operates independently. That kind of makes sense, right? So you can't really have a subpart of this thing that operates independently of the parent. This doesn't really make sense. They point to Ryan, where the D.C. Circuit stated that depending on its general nature and functions, a particular unit is either an agency or it's not. Once a unit is found to be an agency, this determination will not vary according to its specific function. So, yeah, an agency does not stop being an agency because it does non-agency things, and a non-agency doesn't become an agency merely because it does agency things, right? So you're not looking, strictly speaking, at the functions. You're looking more at what it is, how it's built, how it's constructed, what its relationship is in the executive. Defendants further argue that even if the court did examine the functions of Ramsden separately, Legal has failed to plead sufficient facts to demonstrate it should be considered an agency subject to FOIA. Legal suggests pointing to Armstrong as a straw man, and just because no court has determined that subpart of a non-FOIA entity is subject to FOIA does not mean this court should not make such a determination. Which I suppose is true, kinda, right? If there's no case that says it, then this court could decide it either way, but at the same time, it's a sub-entity within the agency, so would this be the most natural conclusion? Legal claims without citation to any case in this district post-dating Armstrong each time a court has adjudicated a FOIA case against the National Security Council. It has performed a searching sole function examination of the functions of the office, and this fact removes any relevance to the case law cited. As example, Legal points to an out-of-circuit case in which the Second Circuit, after analyzing the functions of the National Security Council and subcomponents, determined that the National Security Council was not subject to FOIA. Right. It's Legal's position that Armstrong and Main Street only determined that the NSC as a whole is not subject to FOIA, but left open the possibility. I guess it does, strictly speaking, but what is the logic for treating them differently? The court agrees with the defendant. The law of the circuit is clear. The National Security Council is not an agency. The court perceives no invitation in this circuit's binding precedent to reevaluate whether subcomponents of the National Security Council and entity itself has not been found to exercise any significant non-advisory function. So all they're doing is advising the president, just like the NSC is. So if the NSC isn't FOIA-able for that reason, the subcomponent isn't. Although Armstrong did not specifically discuss pre-publication review or the RAMSID, the court did consider NSC's role in protecting classified information. When two circuits have determined the NSC as a whole functions solely as an advisory capacity, which is again is true. The National Security Council can't do things itself. That's also very true. So if you look at like any agency within the federal government, and there's so many, but if you just pick any agency within the federal government, they can do things unto themselves. They do things every day. You know, they review things, they do things, they operate continuously. They do things every day. The NSC doesn't do anything. I mean, in terms of like, you know, manifesting some sort of widget. All they do is provide advice, right? There's the members of the NSC, because again, the membership of the NSC is somewhat open to the president, so they can choose kind of who is and is not. So it might be the secretary. Common people might be Secretary of State. It might be the head of FBI. It might be head of CIA, NSA, DNI. You know, would be good candidate people for that, and it could contain other components as well. Usually, chief of staff. Not infrequent, vice president maybe. It just depends on what the president needs and what they don't. But all they do is provide advice. They can't do anything except say, well, here is our collective information, our collective intelligence. Let's get the brain trust into a room and provide you our collective opinion. And then the president makes a decision, and then they start issuing orders to other things based on that. Or they start, like if the president says, okay, I want to bomb this thing, then, you know, then the chairman of the Joint Chiefs or whoever, you know, the watch commander or whoever calls someone calls someone at the Pentagon and says, yeah, the president would like to initiate this attack now. But they can't do it themselves, right? They can only make the phone call. They can't actually like start the attack. You know, they have to call the Pentagon or whatever. So they don't really have power to do stuff. So all the charges against RAMSID are dismissed. So all the stuff dealing with the National Security Council, and that's the stuff that Legal probably would want most, because he was a national security advisor. National security advisor would be another person usually in this group, right? So, excuse me. So, yeah, they were the ones that's primarily the agency that would review this, because they're the ones that would have the most information. So I doubt very much that many of these other things have anything to share. And I also have doubts that they're going to be able to get to anything for reasons we're going to be able to discuss. The parties have moved for partial summary judgment on the counts that charge defendants with improperly denying Legal Eagle's request for expedited processing of its FOIA requests. FOIA allows for expedited processing of record requests when the person requesting records demonstrates a compelling need, in other cases determined by the agency. Compelling need means that the failure to obtain on an expedited basis could reasonably be expected to pose imminent threat to life or physical safety? No. Or with respect to a request made by a person primarily engaged in disseminating information, urgency to inform the public concerning actual or alleged federal government activity. The requester bears the burden of showing that they are entitled to this. Agency decisions on expedited processing are subject to review based on the record of the agency, and they're reviewed de novo. The parties disagree, agreement setters, about whether Legal Eagle establishes an urgency to inform the public about government activity at issue. When evaluating the statutory requirement, the courts must consider three factors: whether the request concerns a matter of current exigency to the American public, whether the consequences of delaying a response will compromise a significant recognized interest, and whether the request concerns federal government activity. The requester must develop the record to display this urgency. As noted, Legal Eagle request for expedited processing submitted to each of the defendants includes the following statement speaking to compelling need. Because the issues surrounding Mr. Bolton's manuscript and government's efforts to prohibit Bolton from providing the requested information, either in his book or his congressional testimony, this request satisfies the compelling need standard for expedited processing, since it's made by a person primarily engaging in disseminating information to inform the public about government activity involving topics of news, which sounds a little conclusory and a little self-serving to my ear. Without focusing on the content of the record before the agency, Legal Eagle argues that records about pre-publication review processes apply to highly popular and controversial tell-all book concern a matter of current exigency of the American public. Although not mentioned in its request, Legal Eagle states it's highly relevant that Mr. Bolton has levied several accusations at the White House of misconduct in the pre-publication review process, and the information related to these allegations would clearly be central to pressing issues of the day in the run-up to a presidential election, which has kind of passed at this point. So if that is his reason for exigency, it has become mooted. Defendants counter that besides the statement noting above in the request, Legal Eagle provides no further information or explanation why the information was time-sensitive, nothing at all to support urgency. I mean, it's not really urgent. There's nothing that will become less, interesting over time. The public may care less, but that kind of speaks against it, not for it. As an apparent concession regarding the inadequacy of the record, Legal Eagle argues and reply defendants should not have ignored commonly known information when evaluating the request for expedited processing. Legal Eagle contends that there's no requirement. Requesters must spell in exacting detail. While something is important, when anyone with even casual awareness of current events would automatically know it's important. I shouldn't have to make my burden because everyone knows it's true. Not necessarily the most persuasive argument I've ever seen. Let's see how it works. The court again agrees with defendants. The record before the agencies failed to establish a compelling need for expedited processing. Congress has made clear judicial review of agency denials of requests for expedited processing must be based on record before the agency at the time of determination, not on commonly known information that the agency should have considered in addition to the record. So the law, which Mr. Eagle presumably can read about and consult, says the agency is supposed to consider the stuff that is before it on the record. It does not say the agency is supposed to consider things in the ether from the milieu. That of course anyone would know this. It's like, well, of course, if anyone would know it, why not mention it? But instead of mentioning it, you just made these very conclusory statements about how it's newsworthy and important and I'm the best. And the court's not impressed because let me explain statute to you. Let me explain how statute read. Statute reads, you should consider the record. Does not read, should consider widely known information in the ether. Right? And the reason for that, by the way, in case you can't figure it out, the reason for that is because if the agency had a duty to consider widely known information in the ether, that's now just another argument, right? That's just another argument. Whoa. Sorry. Press my phone there. That's just another argument now. Because the agency, of course this was widely known. It was published on page 3B of my local paper. And, It's the CIA, so surely they knew about it. They should have considered that too. So the reason that you have to make the record is because if we said, they should consider common knowledge, then the question becomes, what's common knowledge? And you don't want to go down that path. So how about the person that's making the request has a burn? That might be good. Incidentally, if you're wondering what my phone was playing just now, I accidentally hit the play button on my Spotify, and it was playing my gym music from earlier. I went to the gym earlier. I'm feeling very good, by the way. So, just want to let you know. Yes, I'm feeling good. Why not? I mean, I'm not saying that it's anything to brag about. I'm just saying, I'm feeling positive, so. Legal Eagle's requests offer no evidence of urgency to inform the public that would justify placing its request ahead of others. Courts often affirm denials of requests to expedite on comparatively more robust records. Normally, even when it's a lot more than this, you'd say no. So we're going to say no to you. Because Legal Eagle failed to offer evidence demonstrating a compelling need, the court finds defendants properly denied the request and not so much. So we grant summary judgment on a whole bunch of motions. Yeah. Finally, Legal Eagle filed its motion to strike, partial motion for summary judgment, because it characterizes cross motion as inappropriate cross motion. Okay. Legal Eagle takes issue with the fact defendants have already filed a dispositive motion, the partial motion to dismiss, and argues defendants should have filed for partial summary judgment on the counts involving requests for expedited processing when they filed their first dispositive motion. Legal Eagle further contends that because it never filed an opposition to the cross motion for summary judgment, instead styling its submission as a mere reply brief, which I'm not sure how it's different than an opposition, but okay. Defendant's reply brief should be struck from the record under the local rule. And defendants correctly point out its opposition. Rule 56 allows a party to move for summary judgment at any time until 30 days after close of discovery, regardless of whether they have first filed a motion to dismiss on other issues. So, again, let us do things like read law. Let us read the law and see what it has to say. The rules say that you can file for summary judgment at any time prior to 30 days after close of discovery. It doesn't matter if you've moved to dismiss it already. You can still move for summary judgment on it. All right? Now, the court can dismiss you because you're merely being repetitive, but if you have something new to offer, right? So, the rules allow for you to do this. So why are you saying they can't do it? Read the rules. Beyond Legal Eagle's contention, the motion is inappropriate, cross motion, and never filed an opposition, so the local rules prohibit a reply. It cites no legal precedent. Wow. Lawyer citing no legal precedent, man, that's good work. Or a rule supporting its argument that the motion and reply should be struck. In the court, acknowledges defendant would file a combined cross motion for partial summary judgment and opposition to the motion for summary judgment in an order granting an extension to file. A district court, of course, has broad discretion in managing its docket. So the district court can strike things if it wants to because it's not helpful, it's repetitive, it's wasteful. District court has a lot of discretion. So the court will not use the discretion here because we don't have to. We could, we're not going to. Because the rules explicitly allow for it. So if we did, it would probably be an abuse of discretion, right? There is such a thing as abuse of discretion. Courts can go too far. And one of the things that might indicate the court going too far is when they're doing something in opposition to a rule that expressly says the other thing. Now, I won't go so far as to say that's universally true. There probably is some situation somewhere where a court could give an order for someone not to do something even though the rule explicitly allows for it. I'm not sure what that would necessarily be, but it's probably allowable sometime. But what I will say is, if you're going directly against the rule, it's probably going to be an abuse of discretion. So, So, to summarize, counts 1 through 4, 15 and 16 against Ramsett are dismissed. Partial summary judgment, which is to say they're dismissed. 6, 8, 12, 14, and 18. And therefore 5, 7, 9 through 11, 13, 17, 19 through 21 still remain, which is relating to the other agencies and their internal practices. So, yeah, on the legal issues. But they're all going to be denied as internal work product. And they're all going to be denied as internal deliberations, internal work product, and all the rest of it. So they're going to be denied. But he's just fighting about whatever do I even have to bother to respond? So the federal court, the federal groups have been saying, do I even have to bother to respond? And for a lot of them, they said, no, Ramsden doesn't have to bother to respond. All these other things aren't, but yeah, for the other ones, you have to respond. So they'll just put probably exemption number 4 on it and call it a day. So legal basically loses all the arguments he's made to date. And that's from Rudolph Contreras over here, who says no. And so I guess the next thing that will happen will be presumably the response to the FOIA from a whole bunch of things, and it'll probably be like the 4th exemption under FOIA. So, good times. So there were no questions, so let me just take a quick look at YouTube chat and see what's there before I sign off for the day. There were some super chats. Well, thank you very much. $5 from Sledge and Wedge, who says, hooray, I made the reading. Yes, you did. I'm glad to have you here. $5 from Michael Mervitz. Thank you for your analysis. No problem. Rikita Law gives me $20 and says, look at this here, man, doing the Lord's work. Thank you, Nick. I appreciate that. Yeah, we gotta make fun of the eagle, man. We gotta make fun of the eagle, and the court just telling him no. Thank you, Nick. That's very kind of you. $2.99 from Kimberly Mother of Rots, who says, late fee, my bad. And then $2 from Brenda Lee Carpenter. We're sending in super chats to pay a toll. When we're late now, yes, you should definitely pay a toll when you're late. That would be wonderful. You should be here the whole time. So we will see what happens next in all this, but, you know, the legal eagle apparently doesn't know how to read law. So the court kind of embarrassed him a little bit. It said, yeah, you have no precedent for this. You have no precedent for this. The precedent that does exist goes directly against you. You want us to strike a motion. The rules say expressly they're able to file. So no, I'm not going to be doing that stuff. No, just no. And yeah, no. So I suppose the next thing that will happen is the response. So I'm going to sign off for now, man. If you've enjoyed this stream, please remember to give it a like. I'm here for your legal ego related needs. If you haven't subscribed already, you should subscribe. You should subscribe so you can learn more about Legal Eagle's failures and his inability to law, his inability to read the rules, his inability to know that precedent is usually a good thing to have. And if you can't find anything to cite you, maybe that's a problem. You can learn these things by subscribing. And did you know for a mere 99 cents, you too can become a member of the channel? It's true. You can help support this channel instead of Legal Eagle. And I can become the biggest YouTube legal channel and make Legal Eagle sad. That'd be awesome. So help support his channel. Until later, my friends, I'll help all as well. Peace and good night.